Hello, everyone. Welcome to the Beresford Booth Webinar for today, which is Thursday, October 7th. I am JP Diener, and I am going to be presenting today on a topic that is near and dear to my heart, and that is the litigation process. Litigation encompasses many different areas of the law. It's whenever a dispute arises and you have to resolve that dispute by going to court. That is litigation. And I'm going to be looking at the process today from the standpoint of the defense, primarily because if you're a plaintiff, which means if you're the one who's filing the lawsuit, typically you know what to expect. You know what's coming up because you probably hired an attorney and they've told you where we go from here. But if you're a defendant, a lawsuit can come out of the blue. It can be unexpected. And you have to figure out, what are you going to do? And the way that you know you've been sued typically is when you are served by a process server, most often, with a copy of a complaint and a summons. And the complaint lists all of the reasons that the plaintiff is suing you and what they're suing you for. The summons tells you that you have to show up and respond in court, and if you don't, the plaintiff is going to win automatically. So there you are, you've been served with this complaint and the summons, and you have to say to yourself, where do I go? What do I do now? And maybe you've been through this before, but if you haven't been through this before, this is for you. This answers those questions. My first recommendation is that in almost every situation, you should go ahead and consult an attorney. Get an attorney on your side. Hire them if they think that it's a good idea for you to hire them, because there's so many pitfalls in litigation. There's so many pitfalls in the law in general. There are some occasions where it's totally fine if you want to represent yourself, and you have the freedom in this country to represent yourself if you are so inclined to do so. So you can show up at court all by yourself. You don't have to show up with an attorney. You can make your arguments. You can plead your case. You can do what you're going to do. You can do all of that without an attorney. But the chances of being able to successfully navigate the litigation process and navigate the legal system in general are fairly low, just because of how complicated it is. We have a lot of laws in this country. They vary from state to state, from city to city. We have a lot of procedural rules in this country, and all of those can vary from state to state and even from county to county. So the rules that you have to abide by in court in King County, for example, are often very different than the rules that you have to abide by across the state in Spokane County, or even up north in Snohomish County. Those rules change, and procedural rules are almost every bit as important as the underlying law itself, because if you mess up on a procedural point, that can literally lose you your case, or it can make it so difficult to proceed that there's no way you can win in the long run. So the procedural rules are critical, and attorneys know that stuff. They are paid to know that stuff. They know the laws, they know the procedure, and if they don't know the answer off the top of their head, they know where to find it. So hiring an attorney when you have been sued is, 98% of the time, the smartest thing to do. If you don't have a lot of money at stake, it's a very uncomplicated issue, then it's certainly fine to proceed without an attorney. And in small claims courts, you're not even supposed to have an attorney. So those you can do on your own. But if you've been sued and you're in what's called the Superior Court in the state of Washington, in some states it's called the District Court or the Circuit Court, if you're being sued in those courts, it's almost invariably a good idea to hire an attorney. And once you hire your attorney, once you get somebody on board, that person is not only going to know the law, they're not only going to help you navigate the legal system, but they are an advocate for your position. If you hire an attorney, that attorney has to defend you as zealously as they can while staying within the ethical rules that confine all of us. And they're going to argue your case. They're going to take your side. They're going to utilize the law. They're going to utilize the procedural rules, and they're going to argue your case to the court and make sure that you have the best defense or the best prosecution of your case possible. That's one of the great things. They're not only a guide through the process, but they are an advocate. They help you. Once you've done that, once you've hired your attorney, it is absolutely critical that you tell your attorney everything about the case. Do not hide facts. Do not conceal facts. Do not leave things out that you are hoping are not going to be important, or that you are hoping will not come out and you can just keep quiet about them. Do not hide things. Give everything to your attorney. They need to know every little thing about your case in order to effectively defend you. And they'll let you know if something is unimportant. But if there are some bad facts, if there are some things that you're worried about, your attorney is the one who's going to be able to look at those and figure out how to plan for them. The worst thing often as an attorney is when you get into the middle of litigation and the other side provides you with facts and evidence that your client knew about, but they didn't tell you about. You could have prepared for that as an attorney. You could have planned for it. You could have strategized for it. And you build your strategy based on what you know about your client's case. And if you don't know, as an attorney, if you don't know the whole story, you can effectively strategize, and you can effectively defend, and you can effectively make arguments in front of the court, because the other side is going to be able to produce evidence that you just weren't prepared for. So help your attorney. When you hire an attorney, you're paying them money. Make sure that they have all the information and the tools at their disposal. That information constitutes the tools that they need to be able to do their job. So be open and honest with the attorney. And keep in mind that when you're dealing with your attorney, when you've hired your attorney, your communications with your attorney are privileged, which means that you cannot be compelled to submit your communications with your attorney about your case to the court. So if you tell your attorney some bad facts and make them aware of it, the court cannot compel you or the attorney to talk about that conversation. So it's safe and it's smart to share information with your attorney. And once your attorney has all that information, then they can take that complaint and they can answer it. You have to answer a complaint. You cannot just ignore it, because if you've been served in the state of Washington, for example, which is where we're based, and most states have similar rules in this regard, although some are different. But if you have been served with that complaint, as soon as you are served with it, you have just 20 days to file a response, what's called an answer, with the court. And if you do not respond to that complaint within those 20 days, you can be defaulted out. The other side can go to the court and say, hey, listen, the defendant didn't respond in the 20 days. And the court is going to say, well, then we assume that the defendant did not have any valid defenses, did not have any legal arguments against your claim. And they're basically admitting everything that is in the plaintiff's complaint, and the plaintiff automatically wins and the defendant automatically loses. And once that is done, it can be very difficult to set aside an order of default and a default judgment. If somebody comes and sues you for $250,000, even if there's not a really great basis for that case, even if you've got really good defenses to that case, if you don't show up in court and respond, the plaintiff can get a judgment against you by default in the full amount of the $250,000, maybe plus attorney's fees, maybe plus interest. So it's really important to answer that complaint. And once you get an attorney involved, they can help you do that. And when you answer it, you go through the complaint, and every allegation made against you, you either admit it or you deny it. And that way, you're putting the other side on notice and you're putting the court on notice that you have defenses, you don't agree with everything that they're saying in the complaint, and you want your day in court. Also, at the time that you file the answer, it's also a good time and the appropriate time to file what's called a counterclaim. And a counterclaim is a claim against the person who's suing you. So they've sued you, and if you have claims against them, if you've got a reason to sue them, you can countersue them. And that's called a counterclaim. And then you put that in your answer, you make it part of your answer to the complaint and say, not only do I not agree with what they're saying, but I have claims against this person. And now they have to defend against my claims. And if there's multiple defendants, if the plaintiff is suing multiple people, as a defendant, you can also file a cross claim. And a cross claim is a claim against another defendant. So if a plaintiff sues you and some other person, and you have a claim against that other person related to this transaction, you can file a cross claim and say, all right, we're going to get into litigation. I'm going to sue this guy too. So that's the next step, is to do that answer, to do counterclaims, and to do cross claims. Once those initial pleadings are out of the way, you move into something called the discovery process. And the discovery process is where we learn everything that we can about the other side's case. We learn what the other side has as far as evidence to support their claims, and you have to produce your evidence to support your defenses and any claims you have against them. So if there's documents that are relevant, you're going to try to produce those documents. They're going to try to get you to produce those documents. You're going to respond to their request. They can ask you written questions. They can ask you to produce documents. They can also request inspections of your property or even your person. If it's a personal injury case, sometimes they can require you to undergo a medical exam, for example. That happens in the discovery phase. So the discovery phase is literally that time where you just try to find out everything that the other side knows and everything that the other side will be using to support their claim. Almost always things come out in the discovery process that are unexpected, at least for the attorney. And again, this is why I go back to tell your attorney everything, because if you've done that, then there won't be any surprises during the discovery phase. And the attorney can plan the discovery phase better when they know everything about the case ahead of time. Also during discovery, you can have what's called depositions. And depositions aren't just written questions for the other person. That's where you sit a party or a witness down, you put them under oath, and you make them answer your questions, your attorney's questions in person. So as the defendant, you can depose the plaintiff, you can depose the plaintiff's witnesses, you can get them on the record under oath, providing their testimony about what happened. And it's this discovery process with the written questions, the document production, and the depositions, which really sets the stage for the whole trial. There are very few surprises at trial. Surprises at trial make for great movies and great television. But the reality is that once you've gone through the discovery phase, all the cards are pretty much on the table. And we know what is going to come out at trial. It's all about taking what you've learned in the discovery phase and presenting it effectively at trial. So the discovery phase is where you learn everything. And also during this period is kind of overlapping the discovery phase is a period in which either party can file motions, or you can engage in what's called alternative dispute resolution. Types of motions that you can file, typically you see motions to dismiss the other side's case. If you're starting to go through discovery and it's just becoming really obvious that they don't have any evidence to back up their claims and there's no evidence to back up their claims, you can go to court and you can ask the court to dismiss their claims. You can do that either through a procedural motion called a motion to dismiss, or you can do it through a motion for summary judgment. And a motion for summary judgment is kind of like a truncated trial, where you don't put on testimony, but you present all the evidence that you've got to the court, and you say, listen, nobody's arguing about really the facts of the case. The facts are not in dispute. We have all of the evidence here, and the court can easily rule that the evidence leans in our favor. And we don't even need a trial because we can just cut it out here. So those are two of the most common motions that you're going to see during the motions period. There may also be motions to compel discovery from the other side. If you've asked the other side for particular documents or information and they refuse to give that to you, you can go to court, file a motion, and ask the court to order them to produce those documents. And if they don't do it, if they don't comply with the court's order, they can be in contempt. And there's all kinds of sanctions available for people who don't comply with discovery. So in addition to the motions process, you can also engage in alternative dispute resolution. Most often that means mediation. And mediation is where the parties come together with a neutral third party, and that neutral third party, the mediator, helps them try to come to some settlement of their claim, helps them try to resolve their claim with each other. And say, listen, you don't want to go to trial. You don't want to take the risk of having a judge or a jury decide against you. Work together and work out some kind of resolution of the claim. And I am a big fan of the mediation process. I think it is very important to go through. Even unsuccessful mediations can be useful in the litigation process because you learn a lot about your claim, you learn a lot about the other side's claim, and you learn what an independent third party, and the mediator is typically an ex-judge or a practicing attorney or a retired attorney, but somebody else who has experience in this area. You get a feel from them for what they think of your case. So even if you don't successfully negotiate a settlement, mediation can still be valuable as part of the litigation process. If you do not get the case dismissed, you don't have a successful summary judgment motion, or you don't successfully settle the case through either mediation or just informal negotiations, then you're going to end up at trial. Trial is the ostensible endpoint to the litigation process. It's not entirely true, but it's designed to be the endpoint of the litigation process. And trial is where you go in front of a finder of fact, and that finder of fact can either be a judge or it can be a jury. And that decision usually gets made by the plaintiff or the defendant at some point during the litigation process. There's usually a deadline for you to request a jury. And that is a strategic decision that a lawyer can really help you with to tell you, is this a good case to be tried in front of a judge, or is it a better case to submit to a jury? A lot of strategic analysis goes into that question. But in any case, when you get to trial, you submit your case to the finder of fact, the judge or the jury. And that can be in the form of usually oral testimony. You put the witnesses on, you put the parties on, you let them tell their stories about what happened. Sometimes you have expert witnesses to help explain something complicated. If it's a construction case, or a medical malpractice case or something like that, you bring in an expert witness to explain to the judge or a jury a specific area of law or a specific area outside the law to help the judge or jury understand what this case is really about. So you can have expert witnesses, you can have witnesses about just the facts, just what happened. You will testify most likely in a civil dispute, the other side will testify. And you also submit the documentary evidence that supports your claim. If there are contracts, if there's photographs, whatever there may be, receipts, things of that nature, you submit that. And the trier of fact, whether it's the judge or the jury, they take all of that information, all of the oral testimony, all of the documentary evidence that you've provided, they put it all together and they decide who wins and who loses. And that's typically it. And if whoever wins, they tell them whether or not they get money and how much money they get. And if you've asked the court to keep somebody from doing something, which is called injunctive relief, then they decide that issue and they say, listen, you can't do this anymore. Or they say, hey, keep doing it. It's not against the law. You can do whatever you want. So That's that trial process. You get a decision, and it's a binding decision. That said, if you don't like the decision of the trial, if you don't like what the jury said or the judge said, you don't like that final decision, you do have an opportunity to appeal. In the state of Washington, you go up to what is called the Court of Appeals. And you have to have a basis to appeal. So you either have to show something that the judge or jury made a totally wrong decision of law. They got the law wrong. They applied the law incorrectly. Or there was some significant procedural error at trial that resulted in you losing the trial. And the procedural error can be something like, you know, this evidence shouldn't have been allowed to come in. This person shouldn't have been allowed to testify, or this person shouldn't have been allowed to testify on this thing. Or the judge said, this person can't testify, and you think they should have been allowed to testify. So there's a lot of ways to get up to the Court of Appeals, but you can't just say, well, I didn't like the result. It's not a situation where you can just appeal because you lose. There has to be a good basis to bring it to the Court of Appeals in order to see if they will overturn the trial court's decision. And at the Court of Appeals, you submit everything to a three-panel set of three-judge panel. Those three judges listen to your case, they take in all the evidence, and they make the decision about whether or not the trial court made a good decision or a bad decision. If you lose there, you got one more chance. You can go to the Washington State Supreme Court, but again, you got to have a good reason. You've got to be able to point out something the Court of Appeals got wrong that affected your case materially. Then you can go to the Supreme Court, and the Supreme Court's decision is final unless it was a decision about constitutional law, the federal Constitution of the United States. And if that's the case, then you can go all the way to the United States Supreme Court. But those situations are very, very rare. When you have exhausted your appeals, or once you've decided you don't want to appeal anymore, you've got a final judgment, and that's it. And that's the resolution of the whole dispute, and we're done. That's the end of the litigation process, but there is one more part that is pertinent to the litigation process, and that is collection of any judgment that you received or that you had entered against you in trial. So if you are the plaintiff and you've got a judgment against somebody, that's not the end of it. You got to go collect it. It's not a situation where, well, I have a $200,000 judgment against this guy, and now he's just going to pay me. More often than not, you get a judgment against somebody and they don't pay you. And then there are ways in the law in order to get your money. That you can go through those in the collection process. You can garnish wages. You can execute on their personal property, like you can sell their motorhome, or you can sell their boat, or you can do things like that, their farm equipment, whatever it may be. You can put a lien on their house. You could force the sale of their house. There's lots of things that you can do. If you've got a judgment against you because you lost at trial, that's not the end of it either. You may be able to protect yourself through bankruptcy proceedings. Bankruptcy is designed specifically to protect you from judgments and creditors like judgment creditors. So it's not over there. The legal system is one that can go on and on for a long time. It is a maze of rules, laws, procedures, and there are many steps. It's not typically a quick process. It can take months or even years to get through the litigation process from start to finish. And so that's why it's a really, really good idea to have somebody that you trust helping you through the process, guiding you through the process, and advocating for you every step of the way. Thank you very much for joining us today as we go through the litigation process. If you have any questions, please reach out to us here at Beresford Booth. All of our information is on our website, which is under beresfordlaw.com. We got phone numbers, we got email addresses. You can reach out to us, ask a question. If you get sued, we are here to help you. And if you want to sue somebody, call us. We'll help you with that too. Thank you.